A lot of people have entered into contracts just prior to COVID, but COVID disrupted the entire purpose of the contract, and now they're backpedaling, trying to figure out how to get out of the contract.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Gretchen Cothron tears down a very long and detailed construction agreement to show you how a force majeure clause can undermine everything. So, let's tear it down. Gretchen Cothron, thank you for joining the Contract Teardown Show. How are you today?
I'm doing excellent. Thank you for having me.
Absolutely, Gretchen. We are talking about a big old project, a pipeline, specifically the Corpus Christi pipeline project. And we're going to focus on one specific clause, the force majeure clause, which is of interest right now. But I'm looking at this construction agreement for the Corpus Christi pipeline. Before we dig into force majeure specifically, what is this document? When are we going to see this kind of thing?
So this particular document, as you said, it's a large construction document. And I chose this one because of how detailed it is. And given the problems with COVID right now, I think it's very important to really focus on force majeure clauses in contracts.
Yeah, with the stakes in a contract like this, I mean, you can expect that they're going to go crazy and put every word that they could possibly think of. They just threw a dictionary at this thing. The force majeure clause is actually located down in Section 6, and we'll talk about that. But before we jump to that bit, tell us about you. What's your background? What kind of practice do you have? Tell us about your work.
Thank you. So my work, I am a legal consultant. My background is I specialize in criminal defense, civil rights, and contract law. And I would say 90% of my clients are other attorneys. I mainly conduct, I do consultations for other attorneys to help them on complex cases. I write briefs and things like that.
Great. So you're doing a lot of this legal research and writing this stuff. This is, if I can prop up my book over here, this is what I call the legal supply chain in my book in action, right? Everybody sort of being great at their thing and connecting with other people. So I love it. All right. Well, because you're a super nerd, and that's legit what your job is now, we're going to jump into the super nerddom. There's been a lot of talk lately about force majeure clauses, and you've written an ebook on that for Law Insider that we'll make sure to talk about later and include in the show description. But before we, sort of dig into this particular document, give us some brief background on the force majeure clause. We've all heard of it lately. We all roughly know what it is, but what's the special conversation that is being had around force majeure now that matters?
Well, what it is, it's an old French term. It literally means like the strength, so much strength that you can't overcome it. Superior strength, if you will. So force majeure clauses, they're very important. We're hearing about them now because of COVID and other things going on around the world that are disrupting contracts. They are, I think the important thing is to note is that they're different than what we call acts of God, because a force majeure event can be an act of nature, or it can also be an act of a governmental agency. And we are seeing that distinction now in lawsuits.
Yeah, I mean, we're in, as you and I are speaking right now, we're in the middle of wartime, and there's all kinds of contracts that surely are affected by it, which is different than the weather changed. But to your point, we need something to deal with the fact that the parties had an intention when things started, and then the context changed, and now their original intentions just are not that relevant. And we need to talk about how to preserve those intentions, but deliver in a different way. And so I would actually point out, as we talk about it, is that in this particular document we're talking about, the force majeure clause is inside the change order process. It is a change. So we'll talk about that. But before we do, a bit about COVID, about this is, we've had several conversations about force majeure clauses. People are talking about this. Average Joes are watching the news and know that this is a thing now. Like my kids... Okay, my kids don't care about anything that I do, but maybe my kids have been told something about that. People are hearing about this now. How has COVID changed the environment, and what's different about sort of these health crises?
Yes, a big change right now is people they acknowledge that they need some type of escape valve, I guess, in events to get out of contracts. You might have entered in. I'm seeing a lot in Florida, where I'm from now, where a lot of people have entered into contracts just prior to COVID, but COVID disrupted the entire purpose of the contract. And now they're backpedaling, trying to figure out how to get out of the contracts. And if you don't have that force majeure clause or that escape valve, you might end up suffering a lot of losses, monetary and otherwise, and not be protected by your contract.
Yeah, we'll talk more in a bit about the purposes of these sections and whether they're useful. I'm curious your take on it, but let's jump to the contract. Okay, so I'm jumping down to Section 6. Now, the force majeure clause, as I mentioned, is found within Section 6, but Article 6 is not called force majeure. Article 6 is called changes, force majeure, and owner cause delay. What does it mean to you that the force majeure bit is actually inside change order, surrounded by this whole change order conversation?
So that gives the change order process is the process by which to get relief in the event of a force majeure event. With it being in, this is a normal process. This is normal. This was a 2016 contract when this was written. So it was pre-COVID. But given the complexity of this contract and this project they were doing, they did have the foresight to put that force majeure clause in the contract. So I think that that's very important. However, with it being under the change order section, this contract has prescribed a very distinct and outlined way for the contractor to get relief.
Yeah, and I would point out in 6.2a, it literally says the contractor, because there's two sides who can request changes, but specifically the contractor can only be entitled to a change order in the event of force majeure, under 6a, as we'll talk about, acceleration of the work ordered by the owner, suspension in work ordered by the owner, and to the extent permitted under some other sections. This change order section in general seems to give a lot of power, not to the contractor, but to the owner.
Correct. This Article 6 is almost completely, it was definitely written for the benefit of the owner, not the contractor. I will say something interesting that you don't see all the time is in 6.1, subsection C, it does give a layout of what happens if there is a disagreement on a change order. And you don't see that in a lot of contracts. They will just say that it's up to the owner, and then the contractor just has to wait and see what the owner decides. But this does lays out time limitations in the event of a disagreement between the owner and the contractor.
Right. Well, as we jump to Section 6A, 6.8 to talk about the force majeure, let's jump back to the definitions. I'm looking in force majeure under the definitions, and boy, that is a paragraph. Catastrophic storms or floods, tornadoes, hurricanes, earthquakes, other acts of God, wars, civil disturbances, terrorist attacks, revolts, insurrection, sabotage. I made the joke before that, unless you say Ant-Man crushed my building when he was giant Ant-Man, then people seem to think that force majeure doesn't apply unless you if Ant-Man walks through your building. This is a really long paragraph on what force majeure means. Did you have any thoughts on, kind of the depth that they go to describe force majeure?
I did. I like the detail that they went into. I do think listing everything, and we call this the parade of horribles, right? The horrible things that can happen to disrupt the project. And this, you can tell that they were really looking at the pipeline. And this being Corpus Christi, Texas, they were looking at things that might affect that specific, I think it was a 21-mile pipeline. So that's great. I like how detailed it is. But again, this is pre-COVID, so they don't differentiate in their clause between epidemic and pandemic, which are two different things.
Right. Yeah, and I, just as an aside, I lived up the street from Corpus Christi right before Hurricane Harvey made landfall and destroyed where I lived, which was Rockport, Texas. And so, when you're in Texas on the coast, when you're dealing with these oil pipelines, this stuff is real. They do say, it's got to be an event that delays or renders impossible the performance, and it's beyond the reasonable control of the affected party, not due to fault or negligence. Obviously, even in their definition of force majeure, it's about obligations, right? They're not just saying, oh man, all this bad stuff happened. They're still distributing the obligations of the different parties in interesting ways. They're in our previous conversation, the question is, if you put a parade of horribles, are you now responsible for that parade of horribles? Like if you left something out, right? So if you didn't include Ant-Man, are we in trouble now? Well, let's jump down to 6.8. I'm going to go to A. And again, we talked about, how sort of limited the contractor's ability to, how one-sided this contract is. Well, A shows you that. There's a really long paragraph of qualifiers on contractor relief. If the commencement, prosecution, or completion of any work is delayed by force majeure, then contractors should be entitled to an extension, et cetera, but only if contractor is unable to proceed with other portions of the work, et cetera. There's a lot of caveats and addenda to the contractor getting relief. What do you think about this section, about section A under 6.8?
This section, it's well written because I would not want to give the contractor just an open end. So I understand what they're doing. What they're saying is that if you could do other portions of the project, get those done. Don't stop everything just because of this one event, such as COVID. If this was going on, if they were able to do, some things that weren't affected by government regulations or quarantines, they should still be getting those things done. That I agree with. The problem I see here, though, is that the sole remedy for the contractor, and that would flow through to its subcontractors, is an extension of time to complete the project. And if I was an attorney representing the contractor, I would try to negotiate this to get maybe monetary relief for equipment rentals, staff, things like that also.
Yeah, you can imagine a change in the political winds that would make this, delivering this project impossible. And how does the contractor get any kind of relief in that situation? Well, in contrast, 6.8b, owner relief, is very short. Subject to section 6.8c, which we'll talk about in a second, the owner's obligations under this agreement shall be suspended to the extent that performance of such obligations is delayed by force majeure. So, force majeure, contractor, sorry, still do all the stuff except for, and the owner, force majeure, I can't do anything. What do you think about section B here?
Definitely written for the owner's benefit because it does. So it gives the owner free ride to do anything, all their obligations are suspended. They don't have to pay you if they don't want to because of force majeure. But yet, as you saw in section A, the contractor is expected to still work as much as they can and try and get around the force majeure event. So I would have had a problem with this if I was the negotiating this contract on behalf of the contractor.
Well, but it does say subject to section 6.8c, which talks about the payment obligations. It says no obligation of a party to pay monies under or pursuant to this agreement shall be excused by reason of force majeure. So if you're looking at the pile of responsibilities on the owner, it sounds like the only thing that they're saying we're going to keep doing in the event of force majeure is we're going to write a check, but anything else, delivery of any materials or bringing of any staff or whatever else is in this, 100-page document, whatever other obligations are on the owner or actually off the owner in the event of force majeure. What do you think about that? About the owner basically saying, hey man, we'll keep writing the checks, but all the rest of it, you're on your own.
Yeah, it's not good because you think about if you're under government, say the government tells you have to stop work on this pipeline. If you're not working, how are you turning in those receipts or turning in all of your obligations to the owner to get that payment? If you're unable to turn in all of your summaries, all of your invoices, then you're not getting paid. So for them to just say, well, the owner still has to pay.
Right. Yeah, and
It's
I'm imagining, when I lived down there, a lot of my clients were in the military. There's a pretty big military presence down there. And you just imagine the situation where a bunch of these guys, and they were mostly guys, who worked on rigs, were also in the military. So if things in Ukraine go sideways, and as you can imagine, a force majeure event of there's a war in Poland and all these guys are called up, well, now the labor force in that area who can go do the jobs that are on here is significantly reduced. So the cost of the labor force has gone up an insane amount. Sure, the owner has said, we'll give you the money we talked about before, but the actual cost to deliver has gone up like crazy. That your ability to get resources, to get even the equipment to be able to go deliver on this thing, I mean, it's totally changed. Like, thanks for the checks, and that's helpful, but
yes.
that doesn't really get to all the core problems.
No, and if you can get the checks. So I have seen, and a big problem that I saw in the Southeast and in Florida, I've seen some lawsuits popping up now that I've looked at in Florida, where in Florida there was a stop in March of 2020. They said, okay, stop everything. We're going to start back up in May. And then May comes. Oh, wait, no,
Right.
Now we're going to start in June. So that delay, what it caused on construction contracts was that the contractors still had to pay for all the equipment, all those cranes and everything that they had on rental, and keep rented the equipment and keep all their construction workers on contract and paid, but they weren't able to do any of the work.
Right.
And when this went on again and again, and I want to say until the end of August 2020, when construction really picked back up, the owners say, hey, look at the contract. All we're obligated to give you is an extension of time. And some of the contractors were trying to sue, saying, hey, but wait, we had to keep all this staff on. We had to keep paying for the equipment rentals, and we're not getting any compensation for that. So it really hurts the contracting company.
Yeah, I think it's interesting, as we step back and think about the bigger picture of the force majeure clauses, and we've talked about that on this show a couple of times, where we're like, do we need this thing? Can we rely on the common law? And I want to get your take on that. But just in terms of what's coming, look at this moment in history. The funny thing about COVID is the number of people who are saying either, man, we could have never seen this coming, versus the people who are like, we've been telling you this is coming for years. Same that's going on in Ukraine, where you hear some people saying, oh, we never could have imagined Putin doing this. And other people saying, well, this was so obvious that this was going to happen. We're all really good at foreseeability in retrospect. So tell me about the risk, or how you balance the risk of adding a force majeure clause, how much meat you want to add to it. Do you think we even need it? What's the value of having it versus relying on the common law? Because if it was truly foreseeable, then we wouldn't have this problem. What do you think about using force majeure clauses broadly?
I think that they are necessary. I would detail it to the specific project, like this one we saw was detailed to the pipeline in Southern Texas project. So I would detail it, and I would put language in that says unforeseeable or foreseeable. Just because now that we're experiencing COVID, do we say now we've had so many different mutations, you can't really say you can't foresee another mutation or another huge outbreak of it. We can foresee that now, but do we just say, oh, well, you're screwed because we know that it could happen? So no, I would just keep it in there and put the language that says in the event unforeseeable or foreseeable instances.
Well, and you wrote an ebook on using force majeure that we'll be releasing at lawinsider.com/resources. We'll email that out as well. But tell us briefly about the ebook. I mean, I assume you're laying that argument out of why we need this thing, and here's best practices for using it. Is that basically what the book covers?
Yes. I explain briefly what it is, the history of it, why it's necessary. And I do go into detail some of the common law. If you choose to leave out the clause, which I would not recommend, some of the common law laws that you could work with. But I would definitely, and then I go into force majeure clauses and why they are important and different. I mean, look at the supply chain issues.
Oh, yeah.
And also now what we're seeing with Russia and the Ukraine, you know, so often there are things happening that we might not think would impact something that we're contracting on today, but 6 months down the road, you know, it blows up your whole contract. Nothing is working anymore.
Yeah, we don't know. Well, we will include information for that below. Also over at lawinsider.com/resources. We'll have the blog post for this, including links to the contract that we talked about, to Gretchen's ebook, and to contact information. Gretchen, what's the best way for people to reach out to you if they want to learn more about what you do for lawyers?
They can reach out to me on my website, GretchenCothronLaw.com. You could also email me is the best way to get in contact with me. It's cothronlaw@gmail.com, and that's COTHRONLAW@gmail.com.
Great. We'll include all of that as well. We'll want to see you guys next time. If you want to be a guest on the Contract Teardown Show, just email us. We're at community@lawinsider.com. We would love to have you to beat up a document. We will see you all next time. Gretchen, thank you again. Y'all have a good day.
Thank you so much, Mike.